The winds are changing. At least I hope they are. Seems like they could be. I don't know. Or this could all just be, giant pointless political theater that, ultimately ends in nothing good happening. We'll see. But yeah, I woke up to some good news this morning, saw this on my feed, and thought, hey, I'll make the video about this today. Nearly half of state AGs asked SCOTUS to end a birthright citizenship. That's a good thing. Like I said, it's a sign that the winds, like I said, the winds are changing. They, the general uh, the general idea around birthright citizenship is starting to kind of seep into government. Now, the government members in government are ultimately, we're probably still a few years off from actually it being done away with, but culturally, at least rhetorically, the way we're speaking about it, our AGs are talking about it now. A lot of them are. Uh, like where the zeitgeist is kind of moving in that direction. Now, if you followed me for any length of time, you know that I've defended the idea of birthright citizenship before, and I still mostly do for the children of Americans. I wasn't just born in this country. My parents weren't immigrants. Both my parents were born here. All four of my grandparents were born here. All eight of my great grandparents were born here. So my family has been in this country for, you know, damn near 200 years. So I think I deserve birthright citizenship. Members of my family deserve it. People whose parents are American citizens in good standing, they deserve to inherit the citizenship of their parents. That's how I think it should be. Obviously, illegals. Full stop. No citizenship for the children of illegals. No citizenship for the children of legal permanent residents. No citizenship for the children of people here on tourist visas. No, birthright citizenship should only be passed from citizens to citizens. Simple as. I mean, I suppose we could probably you get into a bit of the gray area. It's like, okay, so what happens if your father is a natural born American citizen, heritage American, even? Let's just go ahead and kind of go to the logic, like the most extreme version of this. Your father is a heritage American, but his wife is Colombian or Venezuelan or Filipino, and she only has a green card because she's married to your father, which means she's not a citizen. She is a legal permanent resident. So in that case, do you inherit citizenship? I'd say probably. I'd probably be okay with that. I don't like the idea of at least one parent because then you have situations where, illegals who are pregnant will insist that they were knocked up by some American guy. So there would need to be some kind of check and balances in place, like legal marriage or something like that. Um, I don't know. We'd have to figure it out from there. But generally speaking, no. The only the children of citizens should inherit the citizenship of their upon their birth. Shout out to the Federalist. The attorneys, the attorneys general of 20, or the attorney generals. Jesus Christ, you guys! Editing, Jesus. The attorney generals of 24 states filed a brief with the U.S. Supreme Court supporting the Trump administration's attempt to stop the invasion through a legal loophole of birthright citizenship. That is essentially where people like Hassan Piker, for instance, whose parents are not citizens. I mean, they might have got citizenship now. I don't know the full extent of Hassan's parents' legal status in the U.S. I'm sure they're here legally. If they're not citizens, I'm sure they're either legal permanent residents or green card, something, whatever. But they were Turkish nationals. Neither one of them American citizens. They flew over here and stayed in New Jersey for the last like couple months or 2 or 3 months of I can't remember the exact time frame, but spent the last few months of Hassan's mother's pregnancy in Jersey so that he could be born in Jersey and get American citizenship by birthright. Then they took him back and raised him in Turkey. In my opinion, he should not be an American citizen. Attorney General Jonathan Scarmetti, a Republican from Tennessee, Scarmetti, not Scarmetti, a Republican from Tennessee, and Brenna Byrd, a Republican from Iowa, led the charge alongside nearly every Republican state attorney general in the country with the 37-page brief, asking the nation's high court to side with the Trump administration's argument that the 14th Amendment clearly does not allow for any person born on American soil to automatically become an American citizen. And it doesn't. A lot of people argue that it does. It doesn't. Not only wasn't how the 14th Amendment, it wasn't how the Birthright Citizenship Clause of the 14th Amendment was argued at the time. Argued at the time that it was being written. That wasn't how it was argued. That what it was argued for at the time that it was passed and ratified. Um, and it wasn't until a bad Supreme Court decision years later that suddenly it became if your illegal alien mother shit you out somewhere on top of the magical American soil, you're automatically an American citizen. And I think that was a bad ruling. After President Trump signed an executive order on his first day in office properly interpreting the 14th Amendment and discarding ridiculous left-wing arguments about birthright citizenship, which have allowed illegals to stay in the United States with anchor babies for decades, Washington, Arizona, Illinois, and Oregon sued in order to protect illegals over Americans, because of course they were. These are blue states. Quote, the idea that citizenship is guaranteed to everyone born in the United States doesn't square with the plain language of the 14th Amendment or the way many government officials and legal analysts understood the law when it was adopted after the Civil War, Scarmetti said in a press release. If you look at the law at the time, citizenship attached to kids whose parents were lawfully in the country. Each child born in this country is precious no matter their parents' immigration status, but not every child is entitled to American citizenship. This case could allow the Supreme Court to resolve a constitutional question with far-reaching implications for the states and our nation. After the 4 states sued, low court tyrants in the federal, I like the Federalists, the low court tyrants. It's very, very, very libertarian. I like it. After the 4 states sued, the low court tyrants in the federal judiciary decided to issue nationwide injunctions, which met with a major rebuke at the Supreme Court. However, the Supreme Court did not rule on the merits of the challenge to birthright citizenship at the time, but is expected to decide whether to take the case in the coming weeks. So, the SCOTUS hasn't taken the case yet. We're still, that's still a bit off. Hopefully, they do take the case and they take the time to listen to it, because I think it's a good case. I think okay, so Roberts has been voting with, the big four, Alito, Thomas, Gorsuch, and Kavanaugh, pretty consistently. So we've got those 5. So we've got 4 on lock for this. I'm almost positive that Thomas and Alito and then 2 Trump appointees. I'm almost positive the 4 of them would vote to undo birthright citizenship. Roberts here recently has been voting with these 4 on pretty much everything. So it seems to be, or at least the cases that I've read about. So we might have 5 unlocked. The only one I'm a little worried about would be ACB because of her predilection towards adopting foreign children, which I don't even think is a bad thing. I'm not even saying it's a negative thing. I think it's a good thing. There are orphans out there, and then there are Americans who are willing to adopt those children and raise them as Americans and try to give them better lives. I think that's commendable. I don't think it's a bad thing, but I fear that could taint her opinion on this. But she also likes to pass herself off as a strict constitutionalist. So if she really is as much of a constitutionalist as she claims to be, she knows that the 14th Amendment was not intended to be used this way. So hopefully ACB, comes through on this if it comes before the Supreme Court. The brief shows the history surrounding the ratification of the 14th Amendment and its citizenship clause from the 1860s through the early 1900s, laying out the proper understanding of the clause before it was twisted by opportunistic leftists who wanted to destroy the country by importing culturally unrecognizable people who refused to assimilate. Quote, birthright citizenship incentivizes illegal immigration, which inherently takes a toll on states both through sapping government resources meant for Americans and degrading culture and community, driving down wages and increasing crime and all these other things. Quote, in recent years, we have seen an influx of illegal aliens, over 9 million, overwhelming our nation's infrastructure and its capacity to assimilate, the brief states. Conferring United States citizenship requires a more meaningful connection to a more meaningful connection than mere presence by happenstance or illegality. That connection, originalist evidence repeatedly instructs, was parental domicile. Essentially, your parents had to be. The exact wording of the 14th Amendment was it was like legal residence are as all peoples subject to the jurisdiction of the United States, essentially. Flowery Constitution language, but essentially citizens. Now you can. I probably butchered the quote, so I probably shouldn't opine too deeply on it. The Attorney General dismantled the left-wing state's primary argument, which relies on a case from 1898, United States versus Wong Kim Ark, where a baby was born on American soil to two Chinese nationals and was deemed a citizen. The brief argues that using Wong Kim Ark actually cuts against the argument for birthright citizenship because the parents in the case were legally allowed in the United States and, as the 14th Amendment states, subject to the jurisdiction thereof. So yeah, they're the children of legal permanent residents are apparently them getting citizenship by birth is still on the table, which that needs to be. I mean, I get it. You don't want to kind of throw the baby out with the bathwater. That's not exactly the right idiom to use here, but essentially, you want to baby steps. First, let's get birthright citizenship for the children of illegals off the table. And once that's settled and done, then we can go after the children of legal permanent residents and, essentially non-citizens. Children born of illegals who have been able to evade law enforcement are unequivocally not. The intertwined nature of the Civil Rights Act of 1866 and the 14th Amendment's purpose to engraft its protections, coupled with the legislative history of the two, show that its drafters and ratifiers never intended to use it to import countless illegals. Yes, it was originally put in place to grant citizenship to freed blacks post-Civil War. And also to guarantee that the people of southern states were still everything was copacetic after the war, that everybody's still an American citizen, everything's cool. Indeed, the 1866 CRA counted as citizens only those not subject to any foreign power, so no dual citizenship, essentially. The law stated that, quote, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, no matter their race or color, and without any regard to any previous condition of slavery or involuntary servitude. The 14th Amendment Citizenship Clause and the 1866 CRA worked in tandem to overturn the Supreme Court's 1857 decision in Dred Scott v. Stanford, which declared that U.S.-born descendants of slaves were incapable of attaining citizenship because their ancestors were considered property upon ratification of the Constitution. Which, of course, is a crock of shit if you're going to, unless we had taken every black in the country and dumped them all off in Liberia and just, complete clean break, then there's really no, in my opinion, justifiable reason for why you would have an entire class of freed slaves and then not just grant them citizenship. Quote, the provision also sought to redress the systemic denial of civil rights to freed slaves by prohibiting race-based discrimination on the conferral of citizenship or provision of civil rights, the brief states. Statements from the 39th Congress, which passed the 1866 CRA, make even more clear that the children of illegals were not intended to be included in the Citizenship Clause. Illinois Senator Lyman Trumbull, who was the primary author of the law, used language explicitly excluding the children of persons temporarily resident as part of that Congress's goal, to withhold birthright citizenship from those who did not owe a complete permanent allegiance to the United States and who were not part of the American people. That's why I said, at the time, it was not argued to work the way that the Supreme Court decided it was going to work. Rep. John Bingham of Ohio, who was the primary author of the 14th Amendment in the House of Representatives, said every human being born within the jurisdiction of the United States, of parents not owing allegiance to any foreign sovereignty, is, in the language of your Constitution itself, a natural-born citizen. Senator Jacob Howard of Michigan explained how the Citizenship Clause was interrelated with the 1866 CRA, noting it, quote, will not, of course, include persons born in the United States who are foreigners, aliens, or who belong to the families of ambassadors or foreign ministers accredited to the government of the United States. Again, It was not meant to work this way. It was said explicitly, like what the law was for. To the last point, on those born of to ambassadors and foreign ministers, even the left agrees, which undercuts their overreaching argument that mere presence of the country should result in citizenship. In the 1800s, secretaries of state had denied citizenship to persons born on U.S. soil, or at least twice, because their parents were not subjects of the United States. The brief said. The 19th century lectures on naturalization and citizenship. Supreme Court Justice Samuel Freeman Miller explained that, quote, if a stranger or traveler passing through or temporarily residing in this country who has not himself been naturalized and who claims to owe no allegiance to our government has a child born here which goes out of the country with its father, such child is not a citizen of the United States because it was not subject to its jurisdiction. Plain and simple. If you are not a citizen, your children do not inherit citizenship upon birth. If the Supreme Court ends up taking the case and rules in line with the true understanding of the 14th Amendment and the Citizenship Clause, the Trump administration could start turning the corner on removing the true number of illegals in the country, including those who were erroneously given the ability to stay under the theory that their parents could just get them across the border before going into labor. The other states that joined the brief are Alabama, Alaska, Arkansas, Georgia, Florida, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, North Dakota, Oklahoma, South Carolina, South Dakota, Texas, Utah, West Virginia, and Wyoming. Based Kentucky, my home, the Bluegrass Hills. We out here getting it done. All right. Let me know what you think down below. Do you think that every child who's ever been shit out on American soil automatically should gain citizenship, or do you think that we need to be more selective with who gets to join the private club? And be sure to let me know those thoughts down below. And sub if you're not subbed, and like the video, of course. And follow all my links and follow me everywhere. Follow me on X. Come check out the game streams. I will be streaming later today, as per usual. And yeah. Throw me a bone. I couldn't come up with a joke for this one. Sorry.